So the question of treaty termination or taking other actions to suspend or withdraw from a treaty system is one that the political branches have dealt with a fair amount over history and increasingly, I would say, has become politically relevant within the last 30 years or so. But it's not one in which there's been a lot of clarification through judicial decisions. There was a very well-known decision involving President Carter's decision to withdraw from a treaty relating to Taiwan. But there hasn't been a lot of judicial decisions. So one of the challenges for us as reporters was trying to provide some clarification of this without going too far, without pretending that there were clear legal limits when we really weren't highly confident about that. And so what we did in composing this section was, of course, build on what the Restatement Third had already said on the subject, but also try to take into account a fair amount of political practice and to examine also the judicial signals that we received. And those relate to both the international law on the question, the relative authority of the President and the Congress, and also the willingness of courts to intervene to try to resolve those questions. And we believe, as courts have indicated, that there is law even when courts choose not to intervene, but we also want to try to describe for courts themselves the occasions on which prior courts have considered it relevant and important for them to try to weigh in and resolve a dispute between the President and Congress.
One of the sections in this fourth restatement is on the United States termination or withdrawal from treaties. When we started drafting that section during the last couple of years, it was a less hot-button issue than it seems to be at the moment, with some transition in the government going on, and there's been a lot of discussion in this last political campaign, presidential campaign, about termination of treaties, such as the trade agreements, NAFTA and the WTO agreements, for example. We have tried in our sections, I think, and I think across the board this is true, to not try to think too closely about the particular politics of the moment, and we've tried to draft for a more long-standing politics that we might have. The government obviously changes to some extent its views over time. The presidency often changes party from time to time. Congress's composition changes. And we've tried to draft, I think in all three sections of this restatement, in a way that's more abstracted away from the politics of the moment. Having said that, of course we're aware of current debates, and one significant debate is the extent to which a president can pull the United States out of international agreements. The section that was just approved by the Council takes the position, largely based on long-standing practice, again going way beyond any particular presidency, that if the President acts in accordance with international law or in accordance with specific terms in the treaty, the President is able to pull the United States out of the treaty. So for example, many treaties do specifically allow countries to withdraw if they give a certain period of notice. That would be true of the NAFTA agreement, just to give an example. And so our section indicates the President could act on behalf of the United States to trigger that process of withdrawal. Obviously, we don't take a position on whether it would be wise to do that or good policy to do that. We do make it clear, though, that that's subject to whatever the international law standards are for terminating or withdrawing from a treaty. The other thing we note in that section, which a lot of people have been thinking about lately, is even if the United States pulls out of a treaty, that may leave in place statutory law that Congress might have enacted to help effectuate the treaty. And in our constitutional system, presidents may well have the ability to pull the United States out of a treaty, but they don't have the ability to just terminate or cancel statutes. And so for treaties that have a lot of legislation implementing them, it's likely to be complicated for a president to disengage the United States without enlisting Congress in that effort, given that we may have a lot of statutory law that's really more in the domain of the legislature, not subject to the president's unilateral control. And we note that in one of the notes in that section.